In your medical malpractice lawsuit, if during the course of trial I get the doctor whom you have sued to admit that he was careless, do I go ahead and do the touchdown dance in the middle of questioning and go, yes! I spike the ball and I go, yes! Is that what I do? You think that would be appropriate? Come join me on this walk on the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. There are instances, it doesn't happen always, it doesn't happen often, where I can get the doctor whom you have sued at trial to actually admit that something he did was careless. Now, whether or not it caused you harm is a different issue, but I can get the doctor to admit, all right, doctor, in a patient who presents to your office with the following complaints, such as A, B, and C, you would agree that good medical care requires that you consider X, Y, and Z. Isn't that true? Yes. And you would agree that failure to consider X, Y, and Z in light of these specific complaints would be a violation from the basic standards of care. Is that true? Yes. All right, doctor, let's look at your notes. In this case, Mrs. Jones presented to your office complaining of A, B, and C on this particular date. Isn't that true? Yes. And doctor, is there anything in your note to indicate that you considered X, Y, or Z? No, there isn't. And you would agree that if you did not consider those things, that would be a clear violation from the standard of care. Isn't that true? Yes, it would. Now, what have I done? I've just got the doctor to accept and to admit that failing to consider those three things would be a violation or a departure from the standard of care. I've now gotten an important concession from him, and now I can use that later on at trial. I can use that to question his medical experts, and I will use that very favorably at the time I make my closing arguments. But now, let me ask you this. Let's say I get the doctor to admit those things. I am thrilled. I can't believe he just admitted those things. What do I do in that instance? Do I gloat over it? Do I jump up and down? Do I do the touchdown dance? Do I spike the ball, grab my briefcase, throw it down on the paper, say yes, and now get the jury all confused about why I'm getting so excited? The answer is no, 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 and no. I don't do any of that. Instead, you know what I do? I keep my poker face and I continue asking questions. That's what I do. Why? Well, not only is it unprofessional to do all those things in the middle of a courtroom, in the middle of a trial, it's just not appropriate. I don't want to signal to the defense, I don't want to signal to the jury yet that what I've done is really remarkable. I don't want them to get advance warning or advance notice that this was a critical, important point, because the moment I do that, the doctor will begin to explain away his answer, or the defense lawyer will jump up out of his seat, raise all sorts of objections, and now we get sidetracked dealing with legal objections having nothing whatsoever to do with the concession that I got and what the doctor has admitted. So my goal is, great, I got the answer, let's move on. Now at the end of the trial, when the doctor is no longer on the witness stand and nobody can object to this issue anymore, now I can talk to the jury about it and talk to them about the significance of what it is that the doctor told me when he was on the witness stand. That's critically important. So, to answer the question, can I go ahead and do the touchdown dance? Can I go ahead and spike some papers on the floor, my briefcase, or dance around the courtroom? The answer is no. Although I may be feeling all of those things and maybe want to do all those things, it's totally not appropriate, and I don't want to explain to the jury or to the judge or to my opponent that what I've just done is remarkable. So why do I share this information with you? I share it with you because I was watching a football game the other day, and it was amazing. As the player runs into the end zone and he spikes the ball, I kept thinking, what happens if a trial attorney does that when he now gains a couple of points advantageous to him and his client? Can he do the same thing? You know, I realize you're likely watching this video because you have questions or concerns, or maybe you just wanted to see the beautiful beach. Either way, if you have questions and you have not yet started a lawsuit and your matter happened in New York, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.